Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. I will look today into the discrete concept relevant for procedural sanctions law, namely the concept of annullable sanctions acts, which may be subject to judicial review proceedings in the union courts, namely the General Court and the Court of Justice. And more specifically, we would structure this presentation as follows. We will make a quick reminder of what direct judicial review proceedings in the union courts are. Then we would briefly discuss different types of annullable acts and explain why these distinctions matter for the purpose of considering the judicial review proceedings of the person which is concerned by the acts. We would then discuss three key concepts which will determine whether the act is admissible or not, namely the concept of direct and individual concerns for the applicant of the relevant act, as well as implementing measures necessary to be considered in the context of bringing judicial review proceedings against regulatory acts. And finally, we would put this general discussion into the context of specific case studies which arise in sanctions context. So let's first of all make a brief summary of what are the direct judicial review proceedings in the union courts. We've briefly considered the matters of administrative and judicial review in one of our earlier videos. So here we mainly summarize key points. Judicial review is a key element of the union legal structure, as it allows the courts to ensure the legality of the European law. And for that reason, a direct right of action is set out in Article 263 of the Treaty of the Function of the European Union, which sets the legal basis for such proceedings. The relevant provision distinguishes between privileged, semi-privileged, and non-privileged applicants. The private individuals will fall into the third category of non-privileged applicants, where the conditions for bringing the proceedings are the strictest, which is logical, as it would not be a functioning legal order which would allow every single individual to bring indiscriminate and unrestricted judicial review proceedings with respect to any type of European act. Normally, the proceedings are brought in front of the General Court. There are certain exceptions with respect to legislative acts, which may need to be brought in front of the Court of Justice, but in the context of this presentation, namely sanctions proceedings, this is irrelevant, as most of the cases will not relate to the legislative acts, as we would discuss in the course of the presentations. So the first instance court will be the General Court, and then the decisions of the General Courts are subject to the appeal to the European Court of Justice. There is a short limitation period, which is allocated to bring in action, which is pretty standard for judicial review proceedings in national member states as well. The period is 2 months from the date normally of the publication of the relevant act in the official journal of the European Union. Normally the sanctions acts will be publishable in this journal. The deadline is less critical for those measures which impose asset-free sanctions with respect to companies or individuals. The reason being is that those sanctions are subject to periodic review typically on an annual basis, sometimes on a 6-month basis. And then each of those acts which renews the asset freeze sanctions for an additional period is subject to judicial review challenge in its own name. And for that reason, to the extent, for example, the applicant missed the original deadline for the initial listing challenge, he or she can very well do so with respect to any subsequent renewal of the measures. The situation is more complex with respect to those measures which impose, for example, sectoral sanctions, or in the context of asset-free sanctions, impose certain positive obligations, like an obligation to report assets, which is subject to an asset freeze. These type of measures will not be typically subject to the periodic review. There may be certain amendments in the course of the life of the regulation, and those amendments may be challenged in their own name, but the original text is set once and for all. And for that reason, to the extent an applicant wishes to challenge that original text and the relevant deadline is missed, then the only potential recourse for that applicant would be to bring the preliminary review proceedings in the national courts with respect to that measure. But this is suboptimal, as the practice is that to the extent the direct route is available to the applicant through the union courts, then the indirect routes through the national courts may not be available to the same applicant. So in general terms, the deadline is an important factor to be considered. The proceedings can be brought by any natural or legal person, and these terms are interpreted autonomously in accordance with the practice of the Court of Justice. The most recent case which set the rules for the autonomous interpretation of the relevant concept, as well as its broad interpretation with the view to encompass as many persons as possible, was the case of Venezuela, which was recognized to be a legal person for the purpose of the judicial review proceedings. And there are other similar examples of, for example, Tamil Tigers or PKK, which were not formally legal persons, but which were targeted by the EU sanctions measures, and which were also authorized to bring the proceedings. So in essence, the principle here is quite simple. To the extent the relevant measure affects a person, then this person shall be able to have recourse to the courts with a view to review that measure. Final preliminary point to note is that, as mentioned, private individuals are not authorized to challenge each and every legal act. They shall have an interest. The reason being is that otherwise a floodgate of disputes will emerge with the individuals challenging all types of acts. Furthermore, even if the act affects the interests of a particular individual, additional restrictions apply for his right to challenge that act, as again, if the only consideration would be the adverse effect on the rights of the individuals, a substantial number of lawsuits would arise every year. Let's think, for example, about any type of charges and fees. To the extent every individual which is subject to those fees and charges may be authorized to challenge them, then certainly this would result in the increased number of legal actions in front of the courts. So the courts, and again in this sense it's very similar to the judicial review proceedings in national courts, impose restrictions which make the challenge more complex and more technical from the legal perspective. The overall purpose is to allow the individuals to challenge those acts which somehow separately target them outside of the broader group of persons, and to not allow them to challenge through the courts those acts of general applications which apply to every single person in the relevant group. And that is a complex, certainly, area where different policies considerations needs to be balanced. On the one hand, it's important to ensure that the persons affected by legal acts have effective remedy in courts to the extent those acts are unlawful or are otherwise passed due to procedural, for example, improprieties, and on the other hand, regulate the number of lawsuits. So that's in essence the scope of this presentation. I will discuss in more detail what type of sanctions acts may be challenged and what are the conditions for bringing those proceedings. So let's first of all briefly summarize the annullable acts as a general category. These acts are set out in Article 263, which provides for the direct actions of persons to review union acts in front of the union courts. And I here propose a breakdown of those provisions to make the follow-up analysis more structured. The first category of acts are the acts addressed to a person. If the act is addressed to a person, then the analysis stops here. This means that this person is somehow singled out of the generic category of the same persons, and accordingly, this automatically vests the right into such person to challenge the act on those bases which are available for him to review those measures, which are summarized in the same article and mainly relate to procedural improprieties, lack of competence to adopt the act, breach of treaties or other norms of EU law, and abuse of powers. These are the limited grounds. We do not discuss them further in this presentation, but we previously discussed them in the earlier presentation related to judicial review of EU acts and those grounds which are often used in this litigation, and those of them which are successful or not. Second category of an act is an act which is of individual nature. So it's still addressed to a single person or a certain close group of persons. So it's not generically formulated act, but is not addressed to the applicant who would wish to issue the proceedings. If the act is not addressed to the applicant, then the applicant may be able to issue the proceedings to the extent the applicant is able to demonstrate that this individual act has direct and individual concern for him. We would later consider what are these concepts of direct and individual concern, which are key for understanding the difficulties of bringing the relevant proceedings and the likelihood of admissibility challenge being successful or not. Third category are generic acts. Generic acts, by definition, are not addressed to a particular person, so they are not addressed to the applicant, as well as they're not addressed to any other third person. That makes them different from category 2. Now, if we deal with the generic act, then certainly this is the act of general application, which is addressed to everyone, is objectively framed, and it's clear that this is these sort of acts which in principle shall be most difficult to review upon the application of private persons not specifically identified in those acts. Nevertheless, there is still an option to bring proceedings against this type of acts, and on first impression, the criteria are similar to those for challenging an individual act, namely an applicant shall demonstrate direct and individual concern, but as we would discuss in the course of this presentation, individual concern criteria is different for general acts as compared to the individual acts, and this is the key difficulty in bringing these proceedings. The last category is a so-called regulatory act. We will discuss in the course of the presentation what it does mean. And in case of the regulatory act, the key point is that the applicant does not need to prove individual concern, only direct concern has to be proved. But then there is an additional requirement that this act is not subject to implementing measures. Again, the concept which we would discuss later in the course of this presentation. So looking at these different categories of acts, we need to answer a few questions. So what is really a distinction between an act, an individual act, a general act, and a regulatory act? Number one, an applicant shall be able to classify the type of act the applicant wants to challenge with clarity, because otherwise the applicant would not be able to identify those criteria which need to be satisfied with respect to this act and adduce evidence that the applicant satisfies these criteria. Key concepts which are relevant for any act which is not addressed to the applicant is the concept of direct concern, would be relevant for the acts of category 2 and 3. And then the concept, and 4, actually all 3 categories which are not addressed to the applicant require direct concern to be proven. And then individual concern, which is relevant for categories 2 and 3 only. And then, as I mentioned, the criteria itself is different for each of those categories. Final point is to have the evidence that no implemented measures would be necessary, which is relevant for the purpose of regulatory acts, as we've discussed. And to make the matters even more complex, separate rules apply to the extent the applicant wishes to challenge an act passed under the common foreign and security policy, because as a general principle, those acts are not subject to judicial review of the Union courts at all. So let's now have a quick view of what the act and other categories of acts are. The act is a generic term, and in principle means any type of act which is capable to produce legal effects on the applicant. So the only requirement as far as the act is concerned is that there is a legal effect on the applicant, and this legal effect persists, so the applicant will get some advantage from challenging the act. It's not a purely theoretical exercise, and to the extent this can be demonstrated, the act has a legal effect and the applicant has interest to challenge the relevant act, the act would be challengeable, and it doesn't matter what type of name, form, or authority has passed the relevant act. In practical terms, in terms of sanctions acts, all acts which have legal effect on the individuals or corporations, regardless of whether they are passed by the Council or Commission, implementing regulations which are sometimes authorized to amend the list of persons, those acts will be subject to judicial review. To contrast the reviewable acts with some type of documents which are not reviewable, the most obvious example would be, for example, best practices for sanctions implementations published by the Council, or different frequently asked questions or guidance or opinions published by the Commission, either on its own initiative or at the request of member states. As they are not binding, which is expressly mentioned on all of those documents, they do not create legal effects for the private persons, and for that reason those type of documents will not be considered to be an act and will not be subject to a judicial review. So an act by itself is a generic category, and any type of legally binding document would in principle satisfy the definition of an act. So key distinction is actually to understand the difference between different types of acts. The first distinction which would be relevant today is a distinction between a general act versus an individual act. And the general act is described in the case law as something which is Objectively regulating the situation applies to all categories of persons engaged in general activity without singling out a particular person. Key point to note here is a practical point that any act which does not mention a particular person to whom it is addressed by name is likely to be classified as a general act. So a prohibition not to engage in trade in certain goods or commodities between the European operators and a foreign country is likely to be a general act. A prohibition to, for example, provide financings to certain companies which have state ownership without naming specific companies is likely to be a general act. The same prohibition where specific companies are mentioned by name is likely to be a individual act with respect to those companies and a general act with respect to those persons which are not mentioned by name in the relevant regulation. So in contrast to the general act, then an individual act is the act which applies to a limited number of persons, and typically an individual act would mention those persons by name. That's a rule of thumb. If a person is mentioned by name, the courts are likely to recognize that the act has individual relevance for those specific persons. As I mentioned, in the sanctions law, the courts generally acknowledge that the relevant regulations would have, in part, a generic nature with respect to certain groups of persons, and in part, they may have a individual nature with respect to those persons who or which are identified by name in these regulations. Another important concept is the concept of the regulatory act, which is not defined in the treaties, and it's a case law construct. And a regulatory act is an act of general application, so it shall generically describe the situation without referring to a particular company or particular individual, but which is not passed in accordance with the legislative procedure for passing the European acts. So it's a pretty distinct concept, which has two of these elements in it. So why are these concepts relevant? By way of general summary, and we would look into detail into the next slide, none of this is relevant to the extent the act is addressed to the applicant, because to the extent the act is addressed to the applicant, the analysis stops there. This act is subject to judicial review. But the distinction becomes relevant to the extent the act is not addressed to the applicant, but has legal effect on the position of the applicant, because, for example, the applicant is a corporation operating in that area of trade with the European Union, which is restricted by the sanctions. Then to the extent that applicant is not identified by name, we would see that different tests would apply for that applicant to demonstrate that the act is reviewable and may be subject to annulment. And here the distinction between three types of acts is different, mainly because the individual concern requirement will be applied differently in each of those situations. So now let's quickly have a look at the act addressed to a private person. And as we've mentioned, to the extent the act is addressed to a private person, that private person has, in principle, an unrestricted right of issuing proceedings against such an act, subject to satisfying the overall requirements of the admissible act, namely that the act has legal effect on such a person, and this effect is ongoing, or the applicant has other legal interests to challenge this act. So it's important to know what does it mean that the act is addressed to a person, which in the context of the sanctions regulations is not a obvious question as it may seem to be, as typically those regulations are actually binding on the European operators, especially if we think about the regulations which are adopted in the area of, for example, regulating trade. Or even in the asset freeze sanctions, in principle, the obligation to freeze the assets of a person is not addressed to a person itself, which is subject to asset freeze sanctions. It's addressed to the European operators, which hold the assets of that person. And those operators are under an obligation to freeze those assets. And frankly, in this process, the person subject to this freeze has very limited, if anything, to do. So who is then the addressee of these acts? And here the courts have taken a practical approach and confirmed that, for example, in the case of the asset freeze sanctions, the person listed by name in the regulation will be deemed to be the addressee and accordingly can bring judicial review proceedings in respect of those acts. A branch or representative office is not a separate legal person, so certainly will be also an addressee. Going further than this becomes more complex. And for example, the shareholders of the companies owned or controlled by the person who is listed by name may not be considered to be the addressees and may need to rely on other criteria, which we will discuss in this presentation. So if you're not listed by name in the regulation, or if, for example, sectoral sanctions apply to you and you're listed by name, where it's less likely that the addressee criteria is satisfied, then this person will need to, first of all, classify the act as a regulatory act or the act of individual or general application. And then, depending on that classification, we'll need to satisfy the additional criteria which apply to those acts for the courts to be able to review them. The first criteria, which will apply to any type of act which is not addressed to a private person, so both to acts of general application, individual application, and to regulatory acts, so to all of them, is direct concern criteria. So direct concern has always to be satisfied. And direct concern in its own turn has two elements. The first element is that the act shall affect the legal position of the person. This requirement is interpreted broadly by the courts, and it's not required, for example, that the person somehow is incapacitated in taking some type of transactions or his legal personality is affected in other ways. The requirement is that these criteria shall be placed into context of the purpose, effect, factual and legal position of the person, and, for example, inability of the person to enter into new contracts, even if that inability is the result of its EU counterparties not been willing to sign those new contracts, have been recognized as having an effect on the legal position of the person. So the first element is the legal position shall be affected. And the second element is that the way this legal position is affected shall flow from the act itself and shall not leave any discretion to the national authorities or EU authorities, which are entrusted with the implementation of the act to the extent any implementation is required, how this act shall be implemented. With the idea being that to the extent there is this discretion as to how the act is implemented, then it's the actually implementing act which is subject to the judicial review. So this element has to be satisfied with respect to any type of act. Then, with respect to the acts which are of individual nature or which are of general nature and which are not classified as regulatory acts, the second condition needs to be satisfied is that these acts shall be of individual concern to the applicant. And the individual concern is basically the main gatekeeper, the main hurdle which the applicant has to overcome in order to prove that the claim is admissible. And here the distinction between individual and general acts becomes relevant, because for the individual acts, where the applicant has to prove that he's a part of the closed groups of persons. And for the general act, in essence, it's almost impossible to prove the individual concern of that act, except in certain very limited circumstances when the applicant, for example, can prove that he already acquired certain right which is affected by the act, and that acquired right distinguishes this applicant from any other group, any other person, or that the position of the applicant is so unique that as a result of this unique position, the act affects only this person as compared to any other person in the group. By way of example, where those provisions with respect to general acts have been operative, the example of the first would be the general act limiting the use of the name Crémant only for specific wines originating in Luxembourg and France. And then the challenge brought up by a Spanish company which used the same name for a very long period of time at the time the regulation was passed was accepted by the court on the basis that the acquired right of the brand which was used by this wine producer for a long time authorized it to distinguish itself from the whole world. And the example of the second category will be the Nord Stream 2 challenge with respect to the gas market directive, which was formulated in a way that affected only that particular company, given that it was the only operator of the interconnector between the European Union and the third country, which was at the time of passing the directive affected by its provisions. So we can see in summary that with respect to the general acts, it's almost impossible to prove individual concern, except in those limited circumstances, which I've just mentioned. And with respect to the individual acts, it's actually easier to the extent the relevant person can prove that he is a closed group of persons, but still a very difficult hurdle to surpass in practice. And from that perspective, the regulatory act becomes an important concept to note because it does not require to prove individual concern before bringing proceedings for its challenge. What is required is only the direct concern element, which we've discussed. And the second point is that the relevant regulatory act does not entail any implementing measures, which in essence means that the act is self-sufficient as to the rule which it produces. And this is a much narrower scope, and it's a very important scope because the regulatory act, as we've discussed, would be any act of general application, which means that the applicant does not need to be mentioned there by name, but would only need to prove that the relevant act has direct concern for the applicant. And the relevant act of general application shall not be passed under the legislative procedure, which would be the case for any act in the sanctions area of litigation, because those acts are not passed under the legislative procedure. So it's an important point to note for a sanctions practitioner. Final point to note is that separate rules apply to challenging those acts which are passed in the scope of the foreign and security policy, where the overall principle is that those acts are not reviewable by the Union courts, and the exception is made by reference to Article 263, which we've just discussed. But an important addition is made in that exception, saying that those acts are reviewable only to the extent they are restrictive measures against natural or legal persons adopted by the Council. From that perspective, the relevant restriction is interpreted in a way that to the extent the challenge is mounted against the decision made under the common foreign and security policy, then that decision is subject to judicial review only in the circumstances if it is an individual act rather than a generic act. We will now consider the application of these principles with respect to various situations which we encounter in sanctions litigation. First point to note is that, as we've already discussed, it's important to note that for the purpose of the analysis, the provision of a sanctions regulation is the act rather than the regulation itself. So what is necessary is, first of all, to distinguish those elements of the regulation which is actually the subject of the claim, of the application for judicial review, and it's important to analyze those specific provisions. So certainly a regulation may have tens and hundreds of various different provisions, and it's important to note that the courts have acknowledged that some of those provisions may have be general in nature and accordingly be general acts, and some of those provisions may be individual in nature and accordingly have the features of the individual act. So it's important to distinguish, it's important to understand that classification does not apply to a regulation or amending regulation as a document itself, but to a specific provision in that regulation that imposes a restriction or a positive application on the applicant, which the applicant wishes to challenge. With respect to asset-free sanctions, both the decisions passed in the context of the common foreign and security policy, as well as the regulations implementing those decisions at the EU level, are subject to judicial review because those are acts addressed to listed persons. And furthermore, as they are addressed to listed persons, these are certainly individual acts, which allows also the review of those decisions which formulate the common foreign and security policy with respect to the element. Second type of challenges typically relates to challenging trade and finance sectoral sanctions, namely those type of prohibitions which, for example, prohibit trade in gold or restrict trade in diamonds or in certain commodities or metals, etc. They can be formulated in one of two ways. They can be formulated by reference to specific companies operating in that sector of the economy, or they can be formulated generically. So to the extent they are formulated by reference to a company operating in that sector of the economy, both, again, their decisions and the implemented regulations are subject to the judicial review, as they would be individual acts and would be the acts of direct and individual concern for such a company. Typically, a company will be subject to this type of restrictions. Further, even if the relevant restriction does not mention company by name, the courts in general would allow it to challenge the relevant implementing regulation, which is implementing the decision, to the extent the relevant criteria can be demonstrated that the relevant regulation is of direct concern to the company, to the applicant. But the courts will not allow the same applicant to challenge the decision made under the common foreign and security policy, because as the act is general rather than individual, it cannot be challenged under the pillar of the common foreign and security policy for the reason that we've discussed. Same principles apply to those elements of sanctions law which impose a positive obligation. For example, the obligation to provide certain information to the regulatory authorities with respect to the assets, as those type of obligations will typically be formulated in a generic way without reference to specific persons. The most likely position would be that the persons who are subject to those obligations would be able to challenge the relevant implementing regulation, which makes it binding for them to comply with those obligations on the basis that they have direct effect of them, and would not be able to challenge the decision passed under the common foreign and security policy on the basis that's a measure of general application. Thank you very much for watching. I hope that you found this presentation useful, and I trust that you join me during my next presentations.